$20 billion. That's what the FTC wanted Meta to give up. Instagram, purchased for $1 billion in 2012. WhatsApp, purchased for $19 billion in 2014. Forced divestiture, the breakup of Facebook's social media empire. On November 18, 2025, after 5 years of litigation, Judge James Boasberg delivered his verdict. Meta wins, Instagram stays, WhatsApp stays, the government's case collapsed, and the reason why contains a lesson every investor needs to understand about antitrust law in fast-moving markets. December 2020, the Federal Trade Commission, joined by 46 state attorneys general, files a historic antitrust lawsuit against Facebook. The accusation? Facebook maintained a monopoly in personal social networking through anti-competitive acquisitions. Instagram and WhatsApp weren't just smart purchases. They were killer acquisitions, designed to eliminate competitive threats before they could challenge Facebook's dominance. The FTC wanted the deals unwound, a remedy that had never been successfully achieved in modern tech history. The FTC had evidence, internal emails, where Zuckerberg wrote about Instagram as a competitive threat, communications showing Facebook's buy or bury strategy, documents revealing that Facebook blocked competitors from accessing its platform to advantage its own products. The case seems strong. In 2012, when Facebook bought Instagram for $1 billion, the company had just 13 employees and no revenue. Today, Instagram generates over half of Meta's total revenue. The FTC argued that without the acquisition, Instagram would be Facebook's biggest competitor. This is the FTC's official case page. 5 years of filings, thousands of pages of documents, expert testimony, internal communications, all building toward one goal, proving that Meta monopolized personal social networking. The case went to trial in April 2025. Mark Zuckerberg testified for over 10 hours across 3 days. The FTC presented its market definition. Meta presented its defense. And that defense centered on a company the FTC barely mentioned: TikTok. Here's the critical detail that determined the outcome. When the FTC filed its case in 2020, TikTok was still emerging in the US market. The FTC defined personal social networking as platforms focused on maintaining personal relationships. They included Facebook, Instagram, and Snapchat. They explicitly excluded TikTok, YouTube, and Twitter. That exclusion made sense in 2020. By 2025, it was fatal to their case. If this kind of market analysis matters to your investment strategy, subscribe now. We decode these cases every week. Judge Boasberg's ruling contained an extraordinary observation. He cited the Greek philosopher Heraclitus, who said no man can step into the same river twice. The judge wrote, quote, "In the online world of social media, the current runs fast too. His earlier rulings on motions to dismiss in 2021 and 2022 didn't even mention the word TikTok. Stop. Let that sink in. A case about social media monopoly didn't mention TikTok. The judge noticed. By 2025, TikTok had become, in the judge's words, Meta's fiercest rival. User behavior had fundamentally changed. People didn't just connect with friends anymore. They consumed AI-recommended short-form video. Instagram had to reinvent itself as Reels. Facebook had to pivot its entire feed algorithm. The personal social networking market the FTC defined in 2020 had effectively ceased to exist as a distinct category. And Meta's lawyers made sure the judge understood exactly what that meant. The FTC needed to prove Meta had monopoly power now, in 2025. Not that they acquired potential competitors in 2012 and 2014. Under Section 13B of the FTC Act, the agency must prove a current or imminent legal violation, not a historical one. Meta's defense was elegant. We used to dominate personal social networking. Now we compete with TikTok, YouTube, and everyone else for attention. We're not a monopoly. We're fighting for survival. And here's the personal connection. Think about your own screen time. How much is Facebook? How much is TikTok? Your behavior just validated Meta's defense. Quick question. What app do you spend the most time on? Type it in the comments. The legal battle was really about market definition. The FTC said the market was personal social networking services. Narrow, meta-dominant. Meta said the market was attention and engagement from consumers and advertisers. Broad. Meta just one competitor among many. Judge Boasberg sided with Meta. He found the FTC failed to prove that personal social networking was a distinct relevant market today. Without a valid market definition, there can be no monopoly. Case over. Send this to anyone who thinks antitrust law is straightforward. Meta didn't just argue theoretically. They presented empirical evidence. When TikTok briefly went dark in January 2025 due to legal issues, where did users go? Facebook, Instagram, YouTube. Natural experiments showed platform substitution. Meta conducted field experiments where they paid users to stop using their products. Those users shifted to TikTok and YouTube. Consumer surveys showed people viewed these platforms as interchangeable for entertainment and content consumption. The data was overwhelming. The FTC had its own experts, but they made a critical error. They presented no direct evidence on substitution. No consumer surveys of their own. No natural experiments. The judge noted this explicitly. Quote, "The FTC offered no counter-evidence on substitution. When your opponent presents data and you present theory, data wins." Wait, I know what you're thinking. But Meta did buy competitors to eliminate them. Isn't that still wrong? Here's why antitrust law doesn't work the way most people think. And why Google can't use the same defense. This is NPR's coverage of the ruling. Quote, "Judge sides with Meta in antitrust trial, will not spin off WhatsApp and Instagram." The critical finding: TikTok's rise recast Meta as merely one of several powerful competitors in a broader market. The acquisitions that seemed anti-competitive in 2012 and 2014 didn't create lasting monopoly power because the market evolved faster than the lawsuit proceeded. 5 years. That's how long this case took. The market transformed 3 times over in that period. This is why I investigate these systems. Subscribe to understand how tech economics actually works in courtrooms. But we're not done, because behind every legal victory is testimony that shaped the outcome. Mark Zuckerberg spent over 10 hours on the witness stand, and some of what he said was remarkable. He admitted that the friend part of Facebook had declined significantly. He acknowledged that YouTube was more competitive than Facebook and Instagram combined for creators. He even revealed that he had privately considered spinning off Instagram himself. In 2022, according to internal emails shown at trial, Zuckerberg wrote that most companies actually perform better after they've been split up. He was contemplating whether Meta would benefit from separating Instagram. Think about that. The CEO of Meta, fighting to keep Instagram, had privately acknowledged that breakups can create value, but he was fighting anyway. Because even if breakup might help shareholders, it would reduce his control. Monopolies maximize control. Competition maximizes value. The FTC tried to use Zuckerberg's own words against him. That 2012 email where he wrote, "It is better to buy than compete" about Instagram. His statements about neutralizing competitive threats. But the judge found this evidence insufficient to prove current monopoly power. The spreadsheets don't show the FTC lawyers who spent 5 years building this case, the economists who developed market definitions that became obsolete, the public servants who believed they were protecting competition. They don't teach this timing problem in law school. Now you understand why antitrust struggles with tech. Have you ever changed your primary social media app? Share when and why below. And here's the part that matters for your portfolio. Because I saved the most important comparison for last. Meta 1. Google is losing. Both cases involve antitrust. Both companies are big tech giants. But the outcomes are completely different. And understanding why reveals everything about how to predict future tech antitrust cases. Google cannot use the TikTok defense. And the reason is structural. The nature of their alleged violations is fundamentally different. Meta's case was about past acquisitions, deals the FTC originally approved. The question was whether those acquisitions maintain monopoly power today. Google's case is about ongoing conduct, active exclusive contracts with Apple and device makers. contracts that are being performed right now, the FTC must prove current violation. For Meta, the market changed. Defense wins. For Google, the contracts are current. Defense much harder. Judge Mehta already found Google is a monopolist in August 2024. That finding stands? Check your understanding. Meta. Past acquisitions. Market changed. Wins. Google. Current contracts. Violation ongoing. Loses. Send this comparison to anyone confused about why outcomes differ. This is CNBC's market coverage. Meta stock fell just 0.3% on the ruling. Why so little movement? Because investors had largely priced in a Meta victory. The market understood what the FTC apparently didn't. TikTok changed everything. Meta's current market cap is approximately $1.7 trillion. Instagram contributes over 50% of Meta's revenue. A forced divestiture would have been catastrophic. The market knew the defense would work. You will analyze tech antitrust differently now. The question is whether you apply this framework before the next major ruling. Subscribe to understand market-moving legal analysis before it moves markets. Here's my controversial take. The FTC lost because antitrust law cannot keep pace with technology. Markets that take 5 years to litigate transform 3 times in that period. By the time a case reaches verdict, the market definition is obsolete. This isn't a failure of enforcement, it's a structural limitation of using courts to regulate fast-moving industries. Maybe we need different tools entirely. Tell me I'm wrong in the comments. You can't unknow this framework now. Every antitrust headline, every big tech lawsuit, you'll ask the right question. Is this about current conduct or past actions? That distinction determines outcomes. What case or company should I analyze next? Drop your suggestions below. But the antitrust wave isn't over. Google faces potential breakup of its ad tech empire. The DOJ wants forced divestiture. And the AT&T precedent suggests that breakup could actually increase shareholder value. That investigation is already live on this channel. If these analyses matter to your investment decisions, subscribe and hit the bell. I decode billion-dollar tech wars before they move markets, every week. Click here for the Google breakup analysis, or this one for the Windsurf acquisition drama. See you there.